Good afternoon, ladies and gentlemen. It is 5 o'clock, so we are going to start. I'm going to share my screen. Uh, Just make that one small. Okay, I hope you can all see the screen. If you can't, then just speak up. Remember to mute your microphones and switch off your cameras. I will at the end switch on mine so that you can see. So I'm going to follow the same process as we did previously in the first two webinars, is that I'm going to give the lecture, and then those of you who are in a hurry can then leave, and then the rest can then engage with me if there are questions or discussions that they want. Okay, so today is the third webinar and it's the last webinar. And I hope you've enjoyed it thus far. And I hope you are not completely tired. But yes, remember for all your administrative matters that you must contact Grace. And then the first webinar was more or less on the Constitution. The second one, the main focus was on medical negligence. And today is the last part. Then there you get my email address. If you want to contact me personally with questions or comments, then you are welcome. And then just note that the practical exercises in your study material, we do not provide model answers, as every case differs and every person will approach a case differently. Okay, then just a few general matters as I usually do, but you can see the person on the picture is also tired, as I think a lot of you are tired because it's a lot of reading. But yes, do your best with the portfolios. I've seen the results of portfolio number 1 and I am impressed. You did very well, so congratulations. And if you've got questions on the portfolios, we can talk about it afterwards. Just remember to ask me. Okay, and
Sorry,
then
sorry, sorry, Prof, to interject. We cannot
yes,
see your screen. I apologize.
no, thank you, thank you, thank you. So let me quickly go back.
Thank you.
Oh, thanks. Otherwise, I would not have known. Share screen. Do you see it now?
Yes, thank you very much.
Okay. Thank you. Thank you. Thank you. You're welcome. If you don't hear me or you don't see or whatever, you're welcome to interject. Okay. So I got a email from Mr. Surti, Yusuf Surti, and I want to apologize. I welcome it if you send me emails and you ask me questions, but his email came when I just released the marks of 2,400 final year LLB students, their assignments. And as you know, LLB students, they dispute everything. So my emails went completely berserk. And in between, I got Mr. Yusuf's Surti's email, and I just very quickly responded. And I forgot to give him the real information that he asked. So I am so sorry I did not apply my mind. But he asked for examples in possible medical negligence cases, where to get examples, where to start with your particulars of claim. And the best book that I can advise, it was written by Ian Dutton. Ian Dutton is an SC advocate, and the book's name is The Practitioner's Guide to Medical Malpractice in South African Law. It was published in 2015, and the publisher is Cyber Inc. So I hope you can still find it somewhere on the internet. And from pages 115 to 137, there are examples, and it's very good examples that will give you a lot of guidance where to start and how the particulars of claim will have to look like. So if you've got that one together with the loose leaf of SANER, medical malpractice in South Africa, you will have more or less all the information that you need. But please take note of this one for excellent examples if you want to see where to start. No, that click doesn't want to work. Okay, so just as a summary of the previous work, how to approach a medical negligence case. So I'm just summarizing so that we are on a level again. But before I start with that, I want to make two comments again. I did this in the first webinar, and I'm saying this again. Every bad outcome or every frustration is not necessarily medical negligence. You have to keep that in mind. You cannot, if you are a practicing attorney and a person comes to you, you have to listen to the facts and determine whether there is a case or not. And I'm going to use an example again. If I used it in the first webinar, I apologize, but then I'm just reiterating the facts again. We have friends. He had to go to hospital for a leg operation, an operation on his leg, private sector medical aid. The operation was done. After that, he contracted septicemia. It was so bad, he ended up in ICU, and they were talking about amputation, etc. His wife then lost it, called their general practitioner, the GP, told him about everything, and the GP then said, let's move your husband to a different hospital. They had to sign a lot of forms, indemnity forms, but he was moved to a different private hospital. In ICU, fortunately, they got the septicemia under control. He survived. His leg is fine. So they suffered no damages. Although they were angry with the hospital. They were angry with the surgeons who didn't speak to them. There was no communication. There's nothing that they could claim because there's no damages. No one suffered damages. Yes, a lot of frustration. Yes, a lot of costs for the medical aid, but damages will not be proven. Okay, a year later, the same couple wanted to become pregnant and nothing happened. They eventually went for in vitro fertilization and they questioned everything, only to find out that one doctor told them because of all that happened to him concerning his leg, he's sterile. And now they were even more cross. So they want to institute action because they don't want the doctors or the hospitals to get away with this kind of treatment. But the problem is for you as lawyers, now you sit with the facts and you can see the frustration of the patient. But what are the damages? What are you going to quantify? You cannot quantify the fact that he's sterile. So no attorney should take the case, and I don't think any attorney will, because the legal cost will just be too much, and all you will be able to claim is general damages. And as I told you at the beginning, to prove general damages and to claim general damages is futile in a sense if you do not claim it with other claims. Because to prove general damages, it is extremely difficult, and I don't think it will happen. It's in a few cases. Remember that I think it's Mbele case that I referred you to. But as sad as the facts are, there is no case because there's no damages to be claimed, unless, of course, if the woman ended up in a psychiatric unit and all of that, but that did not happen. So, and even if that happens, it will be difficult. I'm going to give another example. and I think I did this as well, but just once again to reiterate the issue. Young woman, mother of 2 young children. She's a teacher and her husband is a blue collar worker. So they don't earn a lot. The difference between them is barely 1,000 rand. So they both contribute. She goes in for a laparoscopy and eventually she dies. And now you want answers. What happened? Because with a laparoscopic procedure, you're not supposed to cut. So there's not supposed to be blood and the person should not die of blood loss. But now determine the damages. The husband earns a little bit more than the wife. So he did not lose a breadwinner. Yes, he lost his wife. He lost his partner. He lost the person he loves. But you cannot quantify that. So all that can claim will be the 2 children, that little part that the mother contributed. So let's say it's, for example, a maximum of 500,000 rand. It is not worth it to institute the action because the legal costs at the end of the day will be much more than that. If the woman was the breadwinner, then of course it was completely different. Then you institute an action for the loss of a breadwinner and support and all of those. Just a last remark. The person who suffered the damages must institute the action. This year, I teach the module Legal Philosophy at UNISA. And there we teach them, or we highlight the difference of African perspective versus so-called Western perspectives, etc. But a brother cannot go to an attorney and lay charges or claim because of medical negligence on behalf of the mother or the aunt or whatever. The person who suffered. In other words, if it's a woman and she was not attended to during birth and the baby dies, etc., and she had to undergo a hysterectomy, whatever the case may be, she must institute action, not her husband, not her children, not the elders. She, because that is how our law works. So those are just a few things to keep in mind. And really, you have been trained now. When people come to you, do not see millions. Listen first to the facts and see whether there's damages. Remember, I said also at the beginning, for example, a woman goes in to the public sector to give birth, things go horribly wrong, and the baby dies. She cannot institute action because she did not suffer damage. You cannot quantify the life of that child. How sad it is, but those are the facts. Remember, medical law is based on the law of delict, which is part of our common law, and therefore, once you go to court, you will have to prove all the requirements of a delict, and apart from the difficulty of causation, the other difficulty will be damages, especially in a case where a baby dies. And I know this is sad, but these are unfortunately the hard facts. So let's go through the summary quickly. I'm just quickly taking a sip of water. Okay, so you consult with your client. And as I've said last time, you gather all the facts. You listen to your client. Remember, they remember selectively. They're going to focus on all the negative things, but between all of that, try to get all the facts and determine whether there's a cause of action. Then my suggestion, you don't have to do this. This is not the law. This is just an opinion from myself. You ask your client what he or she wants. Are they angry? Do they want money for support? Do they just want closure? Why are they there? Why do they want to institute an action? Because that will help you to see the whole picture unfolds and you will know where your client wants you to go. And then, of course, you obtain the hospital and the doctor's records. As I've said, you can, they're supposed to give it to you. They will never give you the original. They will give you copies and you will have to pay for them. Okay. And then remember, there is a doctrine in medical law. If it is not written down, it did not happen. So the nurse can say, but I did give him the medication or the injection, and I've got A, B, and C that will testify that I did it. If it is not written down, it did not happen. So that is why record keeping, if I train medical or health practitioners, I have a completely different focus, and then I highlight to them the importance of record keeping. Okay, now you've got the records, then you compare it to your client's version and you see whether a story unfolds and whether there is a basis for a claim or not. And once again, I reiterate that every mishap is not necessarily negligence. Okay, but let's say you look at the facts and you can see a picture, you can see what happened. This gave rise to that and that and that and that. You can see that there's a cause of action, someone suffered damages. Then you must get an expert, a medical expert, to look at everything on your desk, at all the records, and then the medical expert must give you an opinion whether that specific doctor or nurse or specialist did not act as the reasonable doctor, nurse, or specialist. Where do you find experts? I told you, you can consult universities, the departments of medicine. You can go to the South African Medical Legal Association's website, or you can speak to your colleagues and they might refer you to people who will act as experts. Then you get your opinion from the expert, and if the expert indicates that he or she thinks there is a case, remember, they cannot definitely say there is a case. They just express an opinion that it seems as if the doctor or the nurse or the specialist did not act like the reasonable doctor or specialist or nurse in those circumstances. So there is a possibility of a case. Then you start preparing your documents. Remember, you can sue on the basis of a deal or a contract or both. And then remember, when it's the public sector, remember the institution of legal proceedings against certain organs of State Act. Remember that creates a good impression if you do that, but I've never seen that the court doesn't condone it if you don't do it, but it's better to do it. Okay, so that is where we ended last time. So that is more or less how a case happened. So I just refer you to a case, and I'm not sure, I think it was asked in the portfolio as well. A case of Mpumalanga, where a baby of cerebral palsy was born, and there the emphasis of that case is on prescription. But what I want you to see in that case, and I am not throwing stones at the big law firms that do medical negligence cases, but sometimes attorneys will play for time. They will, what the court labeled in that case, do case selection. In other words, they will only go for those cases where they can get more money. And that is not the right approach. At the end of the day, when something was wronged or someone was wronged and suffered damages, that person needs help. So you cannot keep this one there and say, I'll come back to you. Let's just see what this happens or that happens. That is case selection, and that is not an ethical way of conducting your practice. And that is why I used that case just to indicate that the courts do not like it if attorneys use case selection. Then just remember the High Court rules. I just want to get it here in front of me. The High Court rules of the Government Gazette of 7 February 2020, specifically Rule 41A, which say mediation as a dispute resolution mechanism, and it became operational on the 9th of March. And if you go for mediation, you will need to make use of an accredited mediator. You will find those also on the SAMLA website, or you can Google. There's organizations that provide mediation services. Just check when you contract or you use a mediator that that person went through the training and that person is actually a certified mediator. Who does the training? SAMLA did it. I'm not sure whether they still do it, but the University of Cape Town also do it, and the University of Stellenbosch. I did it under conflict dynamics, and I got my training there. And I think I've told you last time the training is intense and it is difficult, but I think there's a need for it. I just want to read from Rule 41A. The following rule is hereby inserted: mediation as a dispute resolution mechanism. And then when you go to the defining of mediation, it means a voluntary process entered into by agreement between the parties. And then if you go further, in every new action, the plaintiff or applicant shall, together with the summons or combined summons or notice of motion, serve on each defendant or respondent a notice indicating whether such plaintiff or applicant agrees to or opposes referral of the dispute to mediation. I'm just highlighting this because the court rule is there, but you get these, the bigger firms not willing always to mediate, especially if they go on contingency. But then they have to give reasons why not mediation. But I cannot give you hard and fast rules how to handle situations like that. My suggestion is that when it is, for example, a person that went in for an operation and things went wrong, and that person needed some more operations, etc., sort of easier cases can go for mediation. I think where it becomes very difficult to mediate is in cerebral palsy cases, where you will need a lot of experts because there's a huge determination of future loss of earning, future medical costs, etc. But for other matters, I think mediation is the ideal solution, because I found that a lot of patients who go and see an attorney just wants closure, just wants answers, just want to see the doctor or the specialist face to face and ask questions and hear the story behind the story. But so take note of this rule. Try to do it depending on whether you are for the plaintiff or the defendant. I think it's going to be enforced at some time. I don't think it is yet. But I personally think that mediation is a good solution in medical negligence cases, because there's so many emotions involved if something goes wrong in a hospital or with an operation, etc. Okay, so in this part, this is the last part of your study material. What could possibly be the grounds of justification? Sorry, I'm just drinking water. In other words, the defense, what can the defense say? The defense can say that the person gave informed consent and then prove that. For example, the forms that the person signed, notices on the file of the person. In other words, you cannot come afterwards and say, but I did not give informed consent. Remember, I've highlighted it, I think previously, the Pandy versus Isaacs case. Informed consent becomes tricky when it is concerning sterilization. Sometimes women go and to give birth and then orally say, you can also sterilize me. And then when they go to theater, change their mind and say, no, I don't want to be sterilized anymore. Remember, with the sterilization, it must be in writing because of the Sterilization Act. So it cannot just be orally a yes or a no. It have to be in writing because the Sterilization Act prescribes that a sterilization, the consent for a sterilization must be in writing. But you will also note that case Smith, the Smith case, where two procedures were prescribed, and then she alleges afterwards that she did not, Smith versus Beekes, she did not give informed consent for the one procedure and the doctor used the other procedure, etc., etc. That is a Supreme Court of Appeal judgment. So that is also very interesting. I'll go through another few aspects of informed consent just now. Then there's emergencies. I'll speak about that. Statutory authority, a blood sample in criminal proceedings or when it's a risk to public health, what we've just seen, then there can be laws that will keep people indoors because COVID was a risk to public health. And then, of course, court orders. But these grounds of justification exclude wrongfulness in delict. Remember the requirements for a delict. So when you've got a justification, it will take away the wrongfulness and unlawfulness when it is a criminal case. Other possible grounds of justification: contributory negligence, prescription, or there is no causation. But let's go into a little bit more detail on each of them. Okay, informed consent. The locus classicus, the case that you should always study when there is anything disputed concerning informed consent, you go back to the case of Castell versus de Greef. And then just remember the Latin phrase, volenti non fit injuria, to he who consents no harm is done. Then go back to your study material. There all the requirements for valid consent is listed, but also remember the different acts. The National Health Act prescribes informed consent. If I'm correct, it's section 6, 7, 8, and 9. The Mental Health Care Act has specific requirements for consent to be accepted at a psychiatric unit, voluntary or involuntary, whose consent. The Children's Act, always let the red flag rise when you work with children. The Children's Act, remember, gives a child of 12 who are of maturity the right to consent to any medical procedure and with the assent of their parents for an operation, a medical intervention, not just medical care. Then the Choice on Termination of Pregnancy Act, a girl child of any age can go and ask for an abortion, and it will be legal, and then of course within those different categories. And then also the Consumer Protection Act has stipulations on how do you get informed consent. So apart from court cases, remember all these acts, and then also remember the other court cases that came after Castell versus de Greef. If anything that you are dealing with is in the line of informed consent. This is very important. Informed consent is the bottom line of any medical action taken by a doctor, because it goes back to the patient's autonomy, which goes back to the Constitution, your right to self-determination. So everything must constantly have informed consent. For example, a physiotherapist asked me one day, if he goes through a program with a patient, the patient gave informed consent for training for a certain time, and then he has to change the program. Can he just carry on and accept that the patient gave consent for that as well? No. He must get informed consent again. You can never assume informed consent, and consent is not necessarily informed consent. And you have to get informed consent. And that means that all the pros, all the cons, all the risks, all the alternatives, everything must be explained to you in a language that you understand, on a level that you understand. And informed consent, to get informed consent, is the duty of the doctor, not the nurse. And I know they do delegate it. When you are admitted to a hospital, the nurse will come with the file and she will go through all those forms, and you have to say yay or nay and sign, etc. At the end of the day, it is the duty of the doctor to get the informed consent. So the doctor must explain everything to you. Usually he or she will do it in the consulting rooms, maybe not that obvious in the public sector. But informed consent, very sensitive, because it goes back to autonomy and it goes back to your right to self-determination. And I know also a lot of doctors just give you an information brochure and say that you must go and read it, and if you've got questions, ask, or whatever. That, although there's no specific court case, but I think that is dangerous. You still have to talk to the patient and ask the patient questions to determine whether the patient understands everything. I know nowadays when you're admitted to hospital, they ask the patient to write in his or her own language and handwriting at the back of the consent form what the doctor will be doing, in a certain way to ascertain whether the patient understands exactly what's going to happen to him or her. But yes, flag informed consent, that is the bottom line of medical law, because it goes back to patient autonomy. Okay, so just for interest sake, just to combine a lot of things, let's look at an example. The Kuneni family has 2 children. John is 8 and healthy. Frans is 6 and suffers from Down syndrome, as well as other illnesses. He needs a lot of attention and is financially draining the family. Frans's parents met an attorney who is an expert in medical law at a braai, who asked whether tests were done before Frans was born to determine if everything is fine. And then they responded and said, yes, the tests were done because the mother was not in her 20s anymore. And she said that if they detect abnormalities, she would make the choice to abort the baby. Okay, but then the doctor told her there's nothing wrong, and now they have this child, and they do not have the money to support him in such a way. This reminds us of the age versus the fetal assessment clinic. So let's just quickly analyze this. The child is 6. In other words, the parents cannot institute an action anymore because of prescription. But Frans, in his own name, with the assistance of his parents, can institute action, which is then wrongful life. And remember, because of the H versus the fetal assessment clinic, a constitutional court case, you can now go to the High Court, and it is a cause of action to claim for wrongful life. Ew, it is so hot in Pretoria. Okay. Let's analyze this. So the information must be supplied by the specialist, and the specialist did not do it. So, but for the negligence of the gynecologist, this baby would never have been born. I've highlighted previously for you unwanted pregnancy, wrongful birth, and wrongful life. So in the case scenario we had, they will go on the wrongful life because France is already 6 years old. So they will institute it on the basis of wrongful life, and you can refer back to the H versus Fetal Assessment Center. Friedman and Glicksman and Stewart versus Botha, those claims were on the basis of wrongful birth. That is where the parents institute action and say they need money to support their child. But it is the parents who claim, and in wrongful life, it is the child who claims. So this is just to refresh your memories a little bit. Okay, concerning emergency, there's that Latin phrase, negotiorum gestio, that is where someone takes control of you. They do not need consent because you are unconscious, in a coma, or in shock, and it's a life-threatening situation. Then, for example, the emergency workers, they can carry on and do whatever is necessary without your consent because it's an emergency. The National Health Act also makes provision for who can consent when you are unable to make decisions or to consent. And there's a specific order that they prescribe in the National Health Act. Concerning blood transfusions, they are the cases Hay versus B and Phillips versus de Klerk. And I've alluded to the case of Namibia also last time. Remember, if you're an adult person and you are of sound mind, you are still not unconscious, and you can say, I'm a Jehovah's Witness, I do not want a blood transfusion, then that is your personal autonomy and it must be respected. Let's say you are unconscious and they ask your husband or your wife or your partner, and that person say, no, we are Jehovah's Witnesses, no blood transfusion, then there will be no blood transfusion. The exception comes with children. The Children's Act overrules the religion of the parents if it's in the best interest of a child. In the olden days, when the parents were of the Jehovah's Witness faith, and they refused a blood transfusion to their child, then the hospital or the doctor had to get a court order to overrule them. But that have now been changed by the Children's Act. So the hospital or the doctor do not have to approach the court anymore. They can go forth and do the blood transfusion if it's in the best interest of the child. Then deviation from a procedure. This is very sensitive, and a lot of questions come from this. For example, you went in for a liver biopsy. So they were just supposed to check, but while your body was cut open, they saw that the liver is completely full of cancer. In other words, they were just supposed to come with the prognosis, etc. And then they see, hey, we will have to remove the biggest part of this liver. You can do that if it is to improve the health or save the life of the patient. But if at all possible, they should rather go outside the operating theater and get a person to give consent, like a husband or a wife or a major child or things like that. But sometimes time does not allow that. The problem comes in where a woman goes in and gives birth, and this happens more often with vaginal birth than with C-sections. When she gives birth through her vagina, and especially when it's a big child and things go wrong, and the child is out and the afterbirth is out, and they see that the uterus has been damaged completely, and the woman may bleed to death or whatever. And in order to save the woman's life, they then perform a hysterectomy. And then afterwards, the woman's angry and say, "But I never consented to a hysterectomy." This is a difficult situation. I do not think, maybe I'm naive, but I don't think any doctor will just decide, "Oh, let's do a hysterectomy and remove the uterus." I think they will only do that when they see, and remember, we have not been medically trained. We do not know what a damaged uterus look like. So at a certain stage, the specialists need to make a call. Are we going to pull this woman through with the damaged uterus, or will she lose too much blood, or is it in her interest that we remove the uterus, even though it is without consent? It is a difficult one, and it is actually very difficult to prove negligence in these circumstances, because it is very scarce that you will find a obstetric gynecologist that will testify and say the doctor did not act as the reasonable obstetrician or gynecologist, because vaginal birth have a danger to it, especially, as I say, if it's a bigger baby. And when the afterbirth and the placenta and everything goes out, the doctor must make a call and then say, "I think it's better for us to remove." But it can be proven that it was negligence, but I think it's a difficult route to go, to prove that the deviation from the procedure was not in the interest of the patient. Okay, let's quickly look at the facts again, just to keep your minds awake. Thando is 14. He has a chronic kidney disease. He requires blood, which could prepare him for a kidney transplant. The parents refuse, as it is against their religion, so they are Jehovah's Witnesses. It is clear Thando will not survive without the blood transfusion. Thando speaks to the doctor and indicates that he does not follow the religion of his parents and would like a blood transfusion. What now? You, as legal representative of the hospital, are consulted. What will your advice be? What is the first thing to note is that Thando is 14. So the red flag. So Thando is older than 12. He has chronic kidney disease and he is being prepped for a kidney transplant. So one can assume that he is already mature and he understands what's going on. Unfortunately, the Children's Act do not define what is that maturity that you have to look for. So he speaks to the doctor and he says, "I want the blood transfusion." Of course, the doctor will also take into consideration the best interest of the child. But what will your advice be? I assume your advice will be you going forward with the blood transfusion based on the Children's Act because Tandu is above 12, according to you, and that is a very subjective call to make. He is of maturity, he understands what's going on, and he says he wants it. Therefore, the Children's Act, Section 129, gives the doctor the right to overrule the parents because it is in his best interest. Okay, I'm just giving you these things so that you keep your mind going. Contributory negligence. We've spoken about Dube. It's an older one. It's an older case, but it is the guy with the plaster on the arm that was too tight. And he went back to the hospital too late, and the arm had to be amputated. And then the hospital said, but he contributed to the negligence. He should have come back earlier. And then he said, but he did not know for which symptoms to look. And the court said that he did not contribute. Prescription. Okay, there, first of all, this is a nice way for the defense to get out of a situation is to say, but it has prescribed. So where do you start? You start first with the Prescription Act, and then John Sainer made the following comment in his book. A debt shall not be deemed to be due until the creditor has knowledge of the identity of the debtor and of the facts from which the debt arises, provided that the creditor shall be deemed to have such knowledge if he could have acquired it by exercising reasonable skill. So once again, it is a little bit vague. Truter and another versus Duisel, you will see it's 2006, so it's quite a while back, but it went to the Supreme Court of Appeal. It is a sad case. The person had to undergo a series of surgical procedures in his eyes. And it was one operation after the other. And eventually he lost the sight of his eye. And his argument was he could have kept his eye if the doctor didn't perform all those operations, but he could not find an expert to testify that the doctor who operated on him did not act as a reasonable doctor. After 7 years, he heard a discussion over the radio, contacted that doctor. That doctor said, okay, I will come and testify as an expert on your behalf. But then they went to court. It was 7 years later, and the defense said prescription, and the court upheld the appeal. In other words, the court said, yes, you should have instituted action earlier. But that case reminds one of what is first, the chicken or the egg? You cannot take a case to court on the basis of and allege medical negligence unless you have an expert to come and testify that, remember the test for medical negligence, that doctor or specialist did not act as the reasonable doctor or specialist in the circumstances. So if you cannot get an expert, you have no case. And that is exactly what happened in that Truter case. He couldn't find an expert. Yet the court said, but you should have instituted action earlier. So that is sad, and I do not agree with that judgment, but you can make up your own mind. But fortunately, then two cases, the Lynx case and the Loney case, went to the Constitutional Court. And if ever you are confronted with prescription, some or other issue around prescription, then go back to those two cases. The Loney case 2018, so it is fairly recent in the Supreme Court of Appeal, and then the Lynx case was 2016, also fairly recent. And then I've added a new case that went to the Supreme Court of Appeal, the MEC for Health, Western Cape versus MC. You will see it's a 2020 case, which happened in December, or the judgment was given in December 2020. That case will also give you guidance when you are confronted with prescription. Go back firstly to the two Constitutional Court cases, as they are the standing precedents, but also take note of the 2021 from the Supreme Court of Appeal. Then just concerning minors, prescription only commences when he or she reaches the age of 18. In other words, if the child wants to institute action, they can do it until the age of 18, and they have 1 year from the date of their 18th birthday to institute such an action. So, okay, that is prescription. It's complicated, but keep your cool. If the defense come back and plead prescription, make sure that he can actually go back to the Constitutional Court cases and see whether there is a possibility for your client to raise one of those cases and still have the case come to court. It will depend absolutely on the facts. Then concerning damages, there's also something like the divisibility of damages, and there you will see a case. It is against a private clinic, Mediclinic, and in that case they determined that the hospital was 40% negligent and the doctor 60%, and then they split the damages claimed. But there you refer back to the Apportionment of Damages Act. Just remember what I said in the very first webinar, that doctors in the private sector are always independent contractors. So in the public sector, they are employees. So there you will sue the MEC, who is the head of the health sector in that province. But when things go wrong in a private hospital and you are not completely sure whether it's the mistake of the hospital or the doctor, then you sue them both. You cannot just sue the hospital because the doctor is not an employee. The doctor is an independent contractor. And remember, last time we also spoke about the captain of the ship, is that one doctor is not responsible for what another doctor does. So they don't work as a team. You will have to sue them all individually, as well as if the nurses, you accuse them as well, you have to sue the nurses. Also cannot accept that the nurses are employees of the private hospital. They can be there through an agency. Then you must also add the agency, depending on the circumstances of the act. Okay, so you will now see that we go to the end of your study material, where we just emphasize again that South Africa has a private and a public sector. We do not have national health insurance yet. That will come into play in 2026. That is the envisaged date. I don't think it's going to happen because there's not enough money yet. But according to government, they're going forward to it, and the planned date is 2026. Then always remember the Constitution in the background, your right to dignity, your right to self-determination. Right to self-determination links with autonomy. Remember the National Health Act, which prescribes what should happen with health generally. The Health Professions Act, more concerned with the registration and education of doctors. You've got the Nursing Act, and you've got the Pharmacy Act. And then just take note that pregnant women, lactating women, and children below the age of 6 are supposed to get free health care. And in cases of an emergency, we also spoke about this in the first webinar, the person must go to the nearest hospital, even if it is a private hospital and the person does not have medical aid. The private hospital must stabilize that patient and then move them to a public hospital. I wish this could be challenged in court one day, because it really doesn't happen. I even find that private hospitals at some stage, when the ambulances go there, they say, no, we're full, you must go to another hospital. That is no, no, no. The ambulance or the emergency people are supposed to take a person when it's life or death situation to the nearest hospital, who cannot say our emergency department is full. Even if they treat the person in the corridors, they have to stabilize that person and then move to another hospital. This doesn't always happen in practice, but this is what the law say. Okay, and now we have to look at the HPCSA. The Health Professions Act creates the HPCSA, which is the Health Professions Council of South Africa, where all the doctors and physiotherapists, speech therapists, all these people need to be registered. Remember, the people who do not register with the HPCSA, the nurses have their own council and the pharmacists have their own council. But all doctors, all specialists, there are 12 categories that are registered under the HPCSA. This is a way to start. Let's say your client come and see you and you listen, and you see there's no damages to be proven, yet the person is not happy or angry. Then you can advise him or her to go to the HPCSA to report the alleged negligence to the HPCSA. And if you go to the website, they will guide you through the whole process. If it's a minor case, then there's an ombudsman, and the ombudsman will see whether he can resolve the case. So you, as the patient who suffered because of the doctors, and you are very unhappy, yet you survived and there's no damages, you will write everything. For example, the doctor has bad bedside manners, or the doctor was drunk, or the doctor didn't listen, or the doctor never came to you after the operation. There was no aftercare. So those things that bothers you, you write it out in a letter to the HPCSA through the procedure indicated on their website. Then it will go to the registrar. The registrar will look at it and see whether it's serious or not so serious. Not so serious will go to the ombudsman, and the ombudsman will try to settle the issue. If it is more serious, it will go to the preliminary inquiry. All these different specialities have boards, and they have a preliminary inquiry committee, and then they will look at the facts. Remember, audi alteram partem. They will give the doctor a chance to respond. And when they get that response, they will look at it and they will make a determination. If it's of a serious nature, they will then refer it to a disciplinary hearing, and there will be a disciplinary inquiry, a disciplinary hearing, and judgment will be given. If the doctor is not satisfied with the judgment of the disciplinary hearing, he can appeal to an ad hoc appeal committee, or he can appeal to the High Court, or he or she can ask the High Court for a review. And if it goes through the High Court and not satisfied with what comes out there, they can even end up in the Supreme Court of Appeal. When you go through that loose leaf LexisNexis book of SANER, medical malpractice in South Africa, takes you step by step through this process. And I really want you to remember this, so that when a client comes to you, as the example that I had of my friend's leg, you go and report these doctors to the HPCSA. You've got no damages to prove. So it's not worthwhile going for a civil action, but report the doctors. The same with if things doesn't go right, if you give birth in the public sector, but the baby and you survive, go and report the doctors and the nurses involved so that they are disciplined, because they have to entertain every letter they get or every complaint they get. They have to investigate and follow the process. There's the Health Professions Council of South Africa versus De Bruin. I think I asked this as one of your questions for your portfolio. First of all, apologies, there's a lot of big parts in that case that is in Afrikaans, but it doesn't matter. It is just the testimony, but then the judgment summarized the testimony in any case in English. That is the best case that I could prescribe, because it went all the way. It went all the way from the inquiry to the disciplinary hearing, to the High Court, and eventually the Supreme Court of Appeal. Is die krag af? I know. Oh, shit. Bring net gou vir my 'n liggie, laat ek net gou vir Grace bel asseblief.
Professor, we can still hear you.
Can you still hear me?
Yes.
Because load shedding. Can you all hear me?
Yes, we can.
Yes.
Yes, we are hearing you.
Yes, we
we
can.
can.
Hello, is everyone off? It's only my side that is quiet.
No, I think Prof is offline now.
Oh, okay, sure.
Are you still there? Can
Yes,
you
we
hear
are.
me?
Yes.
Yes,
I-
we're still here.
Sorry. I bought a USB or whatever, and sorry, like things went wrong. Okay, let's just share again. I apologize. Share screen. Okay, do you see my screen?
Yes, we do.
Okay, thank you so much. Give me a second. I must just notify Grace just quickly because she's in a. I'll be with you just now. Grace? Yeah, Grace, it's fine. It's fine. We're continuing. Yes. Thank you. Bye. I apologize profusely. Okay. So the De Bruyn case, and this is one of the saddest cases that you will ever read. And you must get your own opinion. I think the bottom line of the case is that De Bruyn said that, but there was no doctor-patient relationship between him and his girlfriend. But I feel that that is not acceptable. What he did was morally wrong. Okay, yes, he was punished, but it's a difficult case to accept that he was allowed to carry on as a doctor. There's two new cases, very, very interesting cases. Those of you interested in working with the HPCSA or referring people to the HSPCA, you will see these are 2022 case and a 2021 case. So they are very recent. The Ludwig case concerns a psychologist who also did therapy, divorce therapy and life coaching, etc. It's very interesting how the court, it ended up in the Johannesburg High Court. So she was not happy with what the HPCSA did, the preliminary committee. So she didn't even go through to the disciplinary process. She went directly when the preliminary committee indicated to her that they found her guilty of unprofessional conduct. She then eventually went directly to the High Court, and the High Court allowed her to appear there because the HPCSA made one big mistake, Audi alterem partem. They did not listen to her explanation, and she was treated so badly that she basically had no other choice than to approach the court. The grief case is a little bit different. That is where a doctor told his patient, so there was a doctor-patient relationship, that they should invest in a scheme, and he made a lot of money in that scheme, and then the scheme things went completely wrong, and a lot of the patients lost a lot of money. The Ludwig case, she did not act as a psychologist. In other words, it was not specifically therapeutic services that she provided. She provided non-therapeutic services. If a psychologist provides therapy, they are also under the HPCSA as long as the therapy is therapeutic. So that is the difference between the two cases. The Ludwig case alleged that she acted independently, not as a psychologist, but as a therapist doing non-therapeutic services to clients. Whereas in the grief case, there was a definite doctor-patient relationship, and he convinced them to invest in a bad scheme. So those are two very recent cases that you can follow up if you are doing work for clients that refer or complain to the HPCSA. Then the mentally ill. This is a specialized area, and be careful to go there if you haven't studied the Mental Health Care Act. There are specifics in that act. So if you ever need to know that, the best is to go back to the act and always remember the review board. The review board that will check whether it was a voluntary or an involuntary, that they are kept in hospital, etc. So I'm not going to go into detail because it's a specialized area and it is not that common that we get negligence cases concerning mental health care. The case that I refer you there is actually just sort of for the fun of it, although I respect the seriousness of the case, but I came across it. It is Williams versus the MEC of Health in the Eastern Cape. This man was an alcoholic, and then he also had psychiatric problems. He couldn't sleep. He couldn't function normally, and he went to the public hospital. He didn't drink for 2 days, and because he was an alcoholic, then they have very severe symptoms that combined with his state that he didn't sleep and that he was schizophrenic, etc., etc. So the doctor prescribed to the nurses that they should give him medicine, but he didn't want to stay in bed. He walked up and down, up and down. They gave him some medicine. They couldn't give everything that the doctor prescribed. And they then said, but they were scared of him because they didn't know what he was capable of doing. So they left him to wander around. And he eventually went into their tea room where there was a glass door. He broke the glass door and he fell. He fell from I think it's the 4th floor. That he fell and he died. And then the wife instituted action and said that there were negligence. The nurses should have known that he has those psychiatric illnesses and that he's an alcoholic and that he didn't sleep well, etc., etc., and they should have taken better care of him. So that is just an interesting, very recent case. If you are interested in that you can follow up. Then other laws, the Consumer Protection Act, there I refer you to the Afrox case. And once again, I apologize. The Afrox case is only recorded in Afrikaans. I don't know why, but you will get a lot of summaries of the Afrox case when you Google it. The Afrox case happened before the Consumer Protection Act. The Afrox case concerns indemnity clauses in hospital contracts where they say they indemnify themselves against any loss or damage that you may suffer. And then Afrox was the previous Life hospitals. This guy took them to court and said, but they cannot indemnify them from everything. But the court said, Supreme Court of Appeal, yes, they can. So that still stays. That is still the precedent up till today. So someone need to challenge those indemnity clauses in hospital admission forms again, but now under the Consumer Protection Act. And then maybe the outcome will be different. Because remember, a patient is a consumer, and the service is the treatment of the patient, and the Consumer Protection Act has 8 fundamental rights, and you will see that it's more or less the same as the Constitution, that everyone is equal, your right to privacy, your right to autonomy, to be informed of risks, etc. It's all there, and if you want to sue or take a hospital or a doctor on the basis of the Consumer Protection Act, you can go to the Consumer Tribunal and then you can lay a claim there. I am not aware of any cases that happened that way yet, so it might still be coming. Then there's something new also, the POPIA, the Protection of Personal Information Act, that is also now part of the health the whole health sector. There are some exclusions, but still the health records need to be protected because it is sensitive and special information. So just keep that in mind. So all in all, if you think about it, how things have changed, it is a doctor and a patient, but at the same time, it is a service provider and a consumer. But according to the POPI Act, it is a data subject and a responsible person. And in the National Health Act, they speak of a user and a service provider. So all these different names of all these different acts as it have evolved over time. And you need to take cognizance of all of that when you are faced with cases. Okay. But then there's another dimension, and I'm nearing the end now. There's also an ethical dimension in medical law. Sometimes it is not that specifically clear what to do. For example, let's say there's a 70-year-old man and he gets a heart attack and he's in the ambulance, but the family members are there with him. He then whispers to the emergency worker, "Leave me alone, I want to die." What must be done? Okay, the wife then say, yes, there is a copy of a living will. She doesn't have it with her, but she knows where it is and she has it. It's there in her cupboard. And the other family members say, no, we don't want him to die. It is extremely difficult. Yeah, the law is clear. You have to accept if he's compos mentis, it is his right to self-determination, it is his autonomy, and you must just make him comfortable. But you should not resuscitate or do anything absolute to save his life. Because he have said, leave me, I want to die. The wife has confirmed that he has a living will, although they did not see it. Remember, a living will has no legal status anyway. It is just a directive. But in that circumstances, you should actually let the person go. Let's change the scenario and make it a 14-year-old child. Some or other illness, and the child of 14 say, I want to die. Can the ambulance people or the emergency people just leave the child? I don't think so, because even though the child is above 14 years, it is not in the best interest of the child to let that child die. These are just things to think about. Let's look at the other one. Mrs. V is 45. She's under the care of a psychiatrist. In other words, she's very depressed. She's suicidal, all of those things. Then she went to the doctor who did a biopsy to see whether she's got cancer. And then the husband tells the doctor, if the tests are positive and she has cancer, tell me first, because my wife, who is suicidal, won't be able to handle it. Can that happen or not? So what do we have here? We've got the wife's autonomy as the patient, the doctor-patient relationship, versus non-maleficence, to do no harm. The 4 pillars of medical ethics is autonomy, beneficence, non-maleficence, and justice. And beneficence is always to do good. Non-maleficence is not to harm. And then autonomy, we all know. And then justice is the fair distribution of what is available. But there is also something like therapeutic privilege. So in this specific circumstances, I think it will be advisable to give the information to the husband, and then your ground of justification will be you do not want to harm the wife because she's suicidal. It is therapeutic privilege for the doctor to decide, and he weighed up her autonomy versus what can happen if she gets the information, and then I think it will be allowable to tell the husband, even though he is not the patient. Okay. Let's think about this situation. A baby is born normal, vaginal birth, and the baby seems to be normal, but it's an early birth at 35 weeks. So after a few days, they discover that the baby have difficulty in breathing. And the specialist, the pediatrician, and they all do tests, and they find out that this baby has a muscle problem and will not be able to swallow. And a lot of surgical procedures are necessary, and no success is guaranteed. And maybe this child will never be able to sit, to walk, or eat independently. So the pediatrician discusses all of this with the parents, and then the parents say, we refuse any procedures. Nothing. We want the baby to die, make him or her comfortable out of pain. We have no more funds. There's no positive outcome. There will be no meaning to his or her life. So we want the baby to die. Can that be done? That is a very, very difficult situation, and it will depend on the doctors, their prognosis, what they say, versus the rights of the parents, versus the right to life, versus the right to quality of life. But these are the kind of things that happen. And if you go into that field, and become a legal advisor to a hospital or whatever, you might come across some of these problems. Just by thinking, we get asked by gynecologists on a regular basis where women, because of cultural practices and beliefs, wants to give vaginal birth and not C-sections. Yet the doctor then explains that her vagina is too small, the opening is too small, her body, her build is too small, and it will danger her life and the baby's life. But at the end of the day, if she insists, then that must be done irrespective of what the consequences might be. The only thing to do is to make very sure that she gave informed consent. In other words, have a written document in her language, maybe get in a pastor or an elder of the community to explain to her on her level, in her language, all the risks. But if she still insists to have a vaginal birth, then that must be allowed, because that then at the end of the day is her autonomy. So the best is just to get it in writing. Another scenario, let's say you are an attorney and you go on contingency. It is a child who suffers from cerebral palsy. The child is already 6 or 7 years old. There's no prescription because you've started in time with the case, but the case have dragged so long, all the experts to get the minutes from them, etc., etc., etc. And you, as the lawyer, your legal firm has already spent thousands of rands. You invested thousands of rands in this case on contingency. You're so sure you're going to win the case. And then, of course, because of the contingency arrangement, you will get all the money back. And then one morning you hear that the child died before judgment has been given. What do you do? Do you tell the court? Because now you cannot claim for future medical costs. You also cannot claim of loss of earnings and the amenities of life, because the child is not there anymore. So your claim will be much smaller, especially if it's in the public sector, because there will not be past medical expenses because it's in the public sector. So what will your claim be? Yet you have invested that. So will you say that the child died? What can you do? What is your ethical duty to do? I don't know. I think some of you can share with us what should be done or should happen. Let's go to another scenario. Your best friend is a doctor and he's a transplant surgeon. So he tells you he is so excited that they're going to do 6 transplants the following day. But it's the domino effect. For example, I am not a match for my son, but I am a match for another patient. So, and another patient is a match for my son. So I don't give to my blood relative, but I give to another person, and that person's blood relative then gives to my child, etc. It's a whole intricate process. And it's like the dominoes are going to fall. There's 3 donors and there's 3 recipients, but they are not blood related. And as your friend, the doctor, goes off duty and he passes the room of one of the donors, he hears that that person is on the phone telling someone else, "Don't worry, I'll have the money soon. I'm selling one of my kidneys." Now, it is illegal in our country to sell a kidney. Now, the doctor doesn't know what to do. You are his friend, the attorney. He calls you. What do you do? If you take that person out, then you're going to affect 6 people's lives. If you keep quiet, you are not transgressing the law, but one of the donors is, and you know about that. What to do? I don't know. I don't have the answer. Okay, as I've said, the exercises are for yourself. I don't think, if I did, forgive me, the ABC versus Thompson medical case, that is a case from Singapore. But if you want to read interesting material, you can try to get hold of that case and read it. What happened there is it is a Caucasian man, he's a German, and he married a Chinese Singaporean. And they couldn't fall pregnant, so they went to an in vitro clinic. They took his sperm and her eggs, and then in vitro means in a laboratory, in a container, they fertilized the egg, and then they planted it back into her uterus, and they got a child, a beautiful boy. 5 years later, but when they harvest your eggs and your sperm, they don't do it one by one. So they take many eggs and a lot of sperm. So it is frozen. It is kept at the laboratory until you tell them to discard it. So after 5 years, they went back to the same laboratory and they said, "Okay, we want another child, please. Once again, take the sperm of my husband. Here, you've got eggs of me and plant it into my uterus. We want another baby." Everything went through, and when the baby was born, out comes a very, very, very dark Indian little girl. Now, what now? They wanted a child, their child. Now they got a child, perfectly normal, beautiful, but it's not theirs. There was a mix-up between the sperm of her husband and an Indian donor. So there's no genetic link between this little girl and the German father. But what do you do now? So it went to court. Okay, obviously the in vitro clinic was negligent and they were fined and they accepted they were negligent and etc. But now you have a child. There was a wrong. But what are the damages? They wanted a child, they can afford a child, but they didn't want that child. Now they have a child that they didn't want. Anyway, it went to court to get clarity, and the judgment of the court is exceptional because it addresses a claim on a basis of a contract and on a basis of a delict, and eventually came to the conclusion a loss of affinity, meaning that the child and the father has no genetic link, and therefore they should be rewarded, and the court awarded an amount for that loss. Fortunately, everything played out very well, and they accepted the little girl, and life went on. But what makes it very difficult, let's say it didn't go that well and there was a divorce. What about maintenance? Because now the father is not biologically the father of that child. It is a very interesting case if you work in that field of specialization. And then the last case that I also found recently, you will see it's 2022. It is a criminal case. But what is interesting about that case is that a lady took a child that came to visit her, strangled her, and then removed some of her organs and her tissue to be sold as muti. And then it is very interesting, and well, I love it to read how the court employed the National Health Act concerning being in possession of human organs and tissue. So if you're interested in that, it's quite a long case, but it's very interesting to see how the judgment went back to the National Health Act and the regulations, etc. Okay, that is all of me. I'm going to stop sharing now and go back to you and switch on my camera so that you can see me. Okay. And now you can ask me, you can comment, whatever you want. So this is it for the 3 webinars. Now it's just your second portfolio where the marks must be published, and then you are done. And once again, I say, if you pass this course and if you pass it well, feel very proud of yourself, because it goes fast and it's a lot of information. Okay, any question? Let me just get there and see. Put up your hand, or you can just speak. There must be questions. Yes, Wesley, you can speak.
Prof, thank you very much. Only to be clear, Prof, in general questions, before an operation in a private hospital, who is responsible for the medical equipment?
Medical equipment meaning like the oxygen and
yes,
things like that.
Yes, in a theater, for example.
Yeah, I do not have a specific answer for you. I will assume the manager of the hospital must have a designated person who check those things. Otherwise, maybe the theater sister must go and check. I honestly, I cannot answer you just like that. I don't know. And it is a concern. I don't know. It is definitely not the doctors, because they are independent contractors just using the facility. But if I was a surgeon and I was going to do a huge back
Yes.
operation or a neck operation, I would go and check for myself, for my own conscience. But and if it's not there, then throw a tantrum and whatever. But the doctor is an independent contractor using the facility. So it will come back to the hospital manager, and it will depend on whether the chief theater sister is employed by the hospital or not. Sorry, it's a vague answer, but that is the situation at this moment.
Why I wanted to ask this question only because I say that a reasonable doctor who must do an operation today, for example, and I agree with you that he must do a type of inspection. Is everything all right? Is everything in a working condition, and etc. You know, and I think that
Yes.
is how a reasonable doctor will act before the operation. But thank you very much, Prof.
Yes, I will just rephrase reasonable now to a caring doctor. Because
Yes,
people will
yes.
dispute the fact that a reasonable doctor, because it's not a specific requirement. So he will say, but it is not a requirement, therefore I'm not unreasonable. But I think the caring doctor, the doctor who's still a doctor because he wants to heal people, will go and check. I once, my son had a hockey accident and his jaw was broken. And the doctor came to me, it was a 6-hour operation, and the doctor, the specialist, the maxillo specialist, came to me after the operation saying everything went well, but he doesn't trust that hospital's ICU. If I give permission, they're going to move my son to the general ward instead of the ICU where he's supposed to go after such a long operation. And I said, why? And he said, he just doesn't trust that ICU. So I gave consent. My son never went there. He went straight to the normal ward, and fortunately everything went well. But that is an indication that that doctor wasn't comfortable with what is happening at that hospital.
Yeah.
Now, as I say, they're independent contractors, so they use the facilities. Some of them are also part of that hospital. They have shares. They have shares in the hospital. Then they may be more concerned. But if they do not have shares in that specific hospital and they just go there from time to time to perform operations, I agree with you, the caring doctor will go and check. I don't think the reasonable doctor will.
Thank you, Professor.
Okay, let's see. There's Wesley, I've spoken to you. QM15684. I don't know what your name is, but your hand is up. QM.
Oh,
Hi,
sorry,
Prof.
sorry,
Yes, you can
sorry.
speak.
My name is Tasha.
Okay. Yeah,
With
yes.
regard to Wesley's question,
Yes.
unfortunately, I'm a theatre sister, so yeah, I know the answer to this. The responsibility
Yes,
of
speak to
checking
us.
the responsibility of checking the anesthetics machine specifically is the biggest responsibility lies on the nursing staff that works in the theatre. Put in the mornings and before the shift, put the machines through the test and ensure that the machine is in working order. It is also the anaesthetist's responsibility to ensure that before he puts the patient, anesthetizes the patient, to also check whether the machine has completed the test and whether it is in functioning order for him. Should there be anything that he worries about or that does not look like it's working, technical department needs to be involved immediately of it. And from there, the company that supplies the machine is also then part of the whole situation.
Thank you. Thank you. Thank you. Now,
Thank you, ma'am.
but your opinion, does it happen that way?
No.
No,
Thank you. You don't have to say anymore. But thank you. Thank you so much. Yes, that's why I say, I mean, I'm an academic, but it's nice to hear from people actually there on the ground what's happening and what they see. I once trained nurses at a private hospital, and the theatre nurse asked me whether the anaesthetist can go out of the operation ward if it's a long operation and go and have breakfast, and then he will come back. And I couldn't believe it. I couldn't believe it. No, no, no. He's being paid. He must stay there. He cannot go out and have a coffee and read the newspaper and then come back. He must be there constantly because the patient's life is in his or her hands, and it's their duty. It's their duty and they're being paid for it. But yeah, apparently at that hospital, the anaesthetist will administer the anesthetics and then leave the operating room and come back later.
It unfortunately
No.
happens in all hospitals.
Yes, but it's a no. It's a no. And remember, when you die under anesthetics, it's immediately an unnatural death that needs to be investigated. It's per se an unnatural death
Yes.
that needs to be investigated. Okay, anyone else? Wesley, you've got another question?
Professor, thank you. Can you only explain for me again, please, Prof, if you don't mind, the termination of pregnancy, the 7 to 14 years old and above 14 till 18 years. The consent matter in that regard, please, Prof, if you don't mind.
Okay, Termination of Pregnancy Act.
Yeah.
Did I hear you correct? There's no age
Yep.
limit. Nothing.
No age limit.
No age limit.
So,
A girl child of any age, and whether she's pregnant at 12, she can decide for herself.
Prof, with respect, what happened to Section 28.2 of the best interest of a child? How can, and I'm not fighting with
I
you,
hear you.
Prof, please.
Yeah, I hear you.
How can
Yes.
a 7-year lady decided she don't know what is going on in the world there, the best interest Section 28.2 of a constitution, and she can make the decision? I still got that same argument.
Yes.
The majority, they must never change it from 21 to 18. For example, 18 years, you come out of school, till 21, you've got 3 years of life experience. And okay, but you know where I'm going.
Yeah,
but
I know where you're
believe-
going. And I'm even going to be worse than you are. What about the father? The father of that
Yes.
baby. Oh, well,
Okay.
the boy that got this young girl pregnant, he doesn't have a say either. It is she. So yes, we assume that girls reaches puberty. It's becoming much younger and younger because of all the hormones in meat and all of those things. So yes, a girl child of 10, 11, when she starts menstruating, she can fall pregnant. And if she falls pregnant, then she has the right to go for an abortion. And remember, there's a specific case, and I can't remember at all, but it happened in the Defense Force, in the military hospital, where a girl went and asked for a legal abortion within the time limits, the first 12 weeks, and the doctor then started sort of preaching for her that what she does is wrong and wrong, and that is against the act. You can actually be taken to court for talking a girl child out of a legal abortion. You're not supposed to influence her or make her feel guilty or threaten her or whatever. It is her choice. It is a choice, and that is the only solution is don't do it. If you don't believe in it, then don't do it. But according to our constitution, people must be given a choice. They must be given a choice, and it is the choice of the girl child. But I hear your concern. There's another thing. There's a lot of controversy concerning age. For example, at 12, the Children's Act, you can consent, but you can only donate your organs or blood at 16, and you're only a major at the age of 18. So that's why I say, whenever you come across a case or a people coming to see you for an alleged case and a child is involved, be very careful. Check all the other relevant acts. Anyone else?
Sorry,
Yes.
sorry, Prof, I don't want to dominate here, but this is our last class, and I want to
Yes.
only to
You're
clarify
welcome.
some. the subjective or the objective test? Prof, please. Can you
Well, it is labeled as an objective test, the test of the reasonable doctor.
Yes.
But my opinion is that no one can ever be completely objective, not even judges. There's always some kind of subjectivity. But in medical law, the test of the reasonable doctor or specialist, nurse or whatever is seen as an objective test, meaning that you will get an independent expert in that field that wasn't there in the circumstances to look at the circumstances objectively. In other words, the science of it, the medical science of giving birth. How would the reasonable gynecologist obstetrician have acted in the similar situation, confronted with that situation at that moment? That's why they call it an objective test, because the expert comes as a complete outsider and supposed to look only at the medical facts and not of the kind of person the gynecologist is. He or she will just look at the medical facts. For example, the water broke at that time, the heart rate was that, the vagina was too small, the baby couldn't get out, there was no ward for a C-section, the C-section was done in the maternity ward, there was so much blood or whatever. So the expert will have to look at it independently, objectively, medically, facts, and then give an opinion. And that's why they call it the objective test. But the reasonable person per se, the pater familias, is, if we go back now to Roman law, is not necessarily always reasonable.
Thank you, Professor. Professor, will you allow me a last question, please?
Yes, you're welcome.
In the honors of proof, in a disciplinary hearing, and in a civil a civil proceedings, is both of them on a balance of probabilities?
Yes. The only way where it is beyond reasonable doubt is in criminal cases. Criminal cases. So a balance of probabilities. My pleasure. Anyone else? I just want to quickly check whether there's questions in the chat. No, I don't see anything. But it is really, well, just me saying that we have load shedding. Okay, anyone else? Remember, you're welcome to email me, and I promise I will answer you. Maybe not immediately, but I will. The students are now a bit more under control. Okay, then if there's no more questions, then that is it. I really, really hope you enjoyed it. I hope you learned something, or at least where to go and find the answers. I still stick to my point that I think medical law is the most interesting field in law, and because there's so much emotion and it combines ethics and the law, etc., etc. But good luck with all your practices and your last portfolio. And yes, maybe we meet again sometime. If there's nothing else, then it's goodbye. Then you can go and have supper.
Thanks, Prof.
Thank you very much, Professor. Thank you.
Thanks, Prof. Bye.
Thanks.
Bye.
Thank you, Prof. It was nice.